Good afternoon. My apologies for the slightly late start to this hearing owing to some difficult technical issues for a number of parties. I'd like to start this preliminary hearing by welcoming all of those in attendance via the virtual link and also any members of the public observing these proceedings via the inquiry's website. I would also particularly like to formally welcome all core participants, a number of whom I'm aware are attending today, and their legal representatives. I regret that the current public health situation has led to this hearing being conducted virtually, but I'm very grateful to those who are assisting behind the scenes to facilitate this, including the Inquiry Secretary, Gemma Ludgate, and her team. All of those actively participating in this hearing will have received technical and housekeeping instructions from Ellis Pennell, solicitor to the inquiry, and I would like to remind you to please follow the guidance included in those instructions to ensure the smooth running of this hearing. The agenda for this preliminary hearing, which has been circulated in advance to core participants and is available on the inquiry's website, is limited to 5 items. Firstly, counsel to the inquiry, Ms. Catherine McGahey, Queen's Counsel, will provide an update on the inquiry's progress to date. She will also outline the inquiry's current proposals in respect of expert evidence. I will then hear submissions on whether the inquiry should seek undertakings from the Home Secretary and/or Attorney General, and if so, on the terms of those undertakings. Fourthly, counsel to the inquiry will address the inquiry's timetable. Lastly, I will hear submissions from those parties who have applied for core participant status, but for whom my provisional decision has been not to grant that status. Written submissions on that matter were requested by the 11th of September and 4 such submissions were received. When we reach that agenda item, I will ask counsel for bail to immigration detainees to make an additional oral submissions on this matter, and will then hear submissions on behalf of detention, action and inquest. All 3 of these applicants are represented by the same team of counsel and solicitors. I will then hear submissions from counsel for medical justice. Before I hand over to Ms. McGahey to provide an update on many of the specifics, I would like to take the opportunity to speak for a few moments about my approach to the inquiry's task. As core participants know, I delivered my opening statement on the 21st of April. The timing of this, a few weeks after the national COVID-19 restrictions were introduced, resulted in that statement being delivered remotely and broadcast on the inquiry's website. Despite the challenges that the last 6 months have brought to us all, I've been determined that the inquiry adapts as best it can to new ways of working and progresses with as much pace as is possible. It is, however, important to acknowledge that the COVID-19 crisis has had an impact on our timetable. The pandemic led to a significant period of time where the inquiry lost access to our dedicated office and hearing space. Crucially, it has also led to real challenges in gathering vital evidence. I'm aware that a number of document providers have faced unavoidable delays in collating and submitting evidence that has been requested of them, and I'm sympathetic to the challenges that they have faced. As Ms. McGahey will touch upon, these COVID-19 related delays are not the only ones that we have faced. I am very aware that core participants are extremely keen for the inquiry's work to progress. I would like to offer them my reassurance that I understand their concerns and am fully committed to carrying out this inquiry with all due pace, while of course ensuring that it is thorough and rigorous in its approach. In my opening statement of the 21st of April, I summarised the issues that the inquiry will address. My statement is available on the inquiry's website, and as such, I do not intend to revisit that list in detail as part of this hearing. However, I do think it will be helpful to briefly summarise the 5 main areas that the inquiry will focus upon. Firstly, it will seek to understand the extent of mistreatment of detainees at Brook House between April and August 2017. Secondly, the inquiry will investigate the extent to which policies, practices, staffing and management arrangements at Brook House caused or contributed to that identified mistreatment. Thirdly, the inquiry will examine the adequacy of the safeguards designed to detect mistreatment. Fourthly, I will examine the changes that have been made in response to the Panorama documentary. And finally, I will look at whether those changes are adequate to prevent future mistreatment of the same nature. In addition, I consider it important that the inquiry examines whether some detainees at Brook House in the relevant period were in need of medical care that they did not receive. Specifically, the inquiry will consider whether unmet mental health needs contributed to detainees' ability to cope and comply with the regime at Brook House. I will examine the operation of Rules 34 and 35 of the Detention Centre Rules, 2001, which include the framework to be used to assess a detainee's fitness for detention where there are concerns about their mental health. I will also consider the degree to which mental health issues may have led to detainees behaving in a way which staff may have interpreted as deliberately disruptive. I intend to commission expert input to assist me in answering this question. A number of core participants have made written submissions concerning the correct interpretation of the terms of reference and on the scope of this inquiry. I am keen to hear submissions from other core participants on this issue, including those who may be granted that status following this hearing. I intend, therefore, to hold a further preliminary hearing in November, details of which Ms McGahey will provide, at which those submissions can be considered. I will not, therefore, hear oral submissions on the terms of reference or scope today. I do, however, at this stage think it may be helpful if I make a few points to indicate the issues and areas on which I intend to concentrate. Other investigations have taken place into the events at Brook House in 2017. This inquiry must build upon and add to those findings. It is my view that this inquiry's role is fundamentally to address the questions of what happened at Brook House between April and August 2017, and crucially, how can such events be prevented? I've been urged to consider matters that go beyond those relating solely to Brook House. As part of my work, I will examine policies and procedures in place at Brook House, including those of the Home Office, G4S Care and Justice, and the healthcare providers. Some or all of those policies and procedures were almost certainly applied nationally, or at the very least in one or more other institutions. Therefore, any findings that I make in respect of these policies and procedures may have implications that go beyond Brook House. I will examine the culture and environment in which mistreatment apparently went undetected. That examination may require me to make comparisons with the management of other institutions. One of my key tasks is to make recommendations for the future. As everyone here is aware, G4S no longer runs Brook House or any other immigration removal centre. I will not, therefore, have the opportunity to look at its current practice in that regard. It will, however, be important to consider the current practice policies and procedures which operate in IRCs now. This will be crucial to ensure that any recommendations that I make will have relevance and are sufficient to minimise the risk of a recurrence of mistreatment, such as that shown on Panorama. If they're not, I will make recommendations for change. It is therefore right to say that my task will not be confined to a consideration solely of events at Brook House. However, I should emphasise that the inquiry's starting point and principal focus will be the treatment and mistreatment of detainees once they had arrived at Brook House. This may involve consideration of whether some detainees, as a result of their physical or mental health needs, should have remained at Brook House at all, or should have received medical care that they did not receive. In particular, as I have said, the inquiry will look at the operation of Rules 34 and 35 of the Detention Centre Rules 2001. But it is not within this inquiry's terms of reference to consider immigration detention policy more widely, or to have specific regard to any individual's immigration or asylum status. This will be a thorough inquiry, but it must also be manageable and conducted within a reasonable time. There would be no point in an inquiry that investigated every possible aspect of individuals' detention, but took so long that many other detainees suffered while it carried out its work, or in an inquiry that made recommendations that were hopelessly out of date by the time that they were published. This inquiry has to be pragmatic. It must concentrate on its terms of reference, and it must focus on making recommendations that will be of practical use in protecting those held in immigration detention in future. I will, of course, listen with an open mind to further submissions on the scope of this inquiry, but thought that it would be helpful to core participants if I set out my current thinking. That concludes my introductory comments. Ms McGahey, I will now turn to you and ask that you please provide an update on the inquiry's progress.
Thank you, Madam. Madam Chair, may I first introduce the representatives who are present today and who will, throughout the inquiry, be representing their particular clients. Firstly, with Ms Saoirse Townsend and Ms Jo Moore, I appear as counsel to the inquiry. Turn now to the core participants. The core participants, who are former detainees, have been anonymised and given ciphers in order to protect their privacy. The former detainee, who is known as MA, along with the Reverend Nathan Ward, are represented by Ms Stephanie Harrison, Queen's Counsel, and Mr Alex Goodman. The former detainees SR and KK are represented by Ms Harrison, Queen's Counsel, and Ms Shushin Liu. Medical Justice, an applicant for core participant status, is represented again by Ms Harrison, Ms Shushin Liu, and Ms Laura Profumo. A former detainee, BB, is represented by Mr Nick Armstrong and Mr Jesse Nichols. They also represent the Gatwick Detainees Welfare Group and the applicants for core participant status, detention action, inquest, and bail for immigration detainees. Another former detainee, known as IA, is represented by Mr Zainul Jafferji. The Home Office is represented by Mr Julian Blake and Ms Emily Wilsden. G4S by Mr Daniel Eisenberg. The BBC by Mr Jude Bunting. Her Majesty's Inspector of Prisons, Ms Claire Dobbin. And finally, the Independent Monitoring Board by Mr Jonathan Dixie. This hearing was initially timetabled to begin this morning. It was rescheduled to start this afternoon in order to accommodate one of the core participants. That is absolutely fine, and this inquiry will always try to accommodate participants wherever it can. However, that does mean that the inquiry is necessarily somewhat shorter than it might otherwise have been. And so we will have to ask core participants to be as succinct as they properly can be when making their oral submissions. However, the Chair has asked me to say that she is willing to sit late this afternoon to ensure that all the agenda items can be dealt with properly and addressed fully. May I turn first now to an update on the evidence gathering of the inquiry, and to turn first to documentary evidence. The inquiry has issued 8 Rule 9 requests for documentation from key organisations. These include G4S Care and Justice, G4S Healthcare, the Home Office and the BBC. G4S disclosure to the inquiry is nearly complete. G4S has disclosed a total of nearly 5,600 documents, running to about 56,000 pages. Much of it names individual detainees. And in order to protect the privacy of those individuals, the inquiry is going through the process of redacting all those names and replacing them with ciphers that those participants in the inquiry can then use. The inquiry has deliberately not yet made a request for confidential medical records relating to individual detainees. The inquiry is very conscious that medical records are likely to include highly personal information relating to individuals, much of which is going to be irrelevant for the purposes of the inquiry. The inquiry therefore intends in the first instance to liaise with each individual detainee whom the inquiry can trace, with a view to arranging disclosure initially to that detainee's legal representatives or to him himself, with onward disclosure to the inquiry and ultimately to core participants of material that may be relevant to the inquiry's work. The inquiry does, though, recognise very clearly that medical records may contain highly relevant information. It has already sought disclosure of documents that may well contain medical information that we know already to have been shared, for example, with G4S and the Home Office. For example, ACDT records and Rule 35 reports. These records, while confidential, are less likely than medical records to contain highly personal and irrelevant material. But the inquiry recognises that it may well, in due course, have to consider the anonymised disclosure of medical records relating to individuals who cannot be traced. Home Office disclosure to the inquiry is also nearly complete. The Home Office has disclosed a total of 2,194 documents, going to over 10,000 pages. The outstanding documents relate mainly to the individual detainees and the records of those detainees. As core participants are aware, the Home Office has confirmed this week that another 3,949 documents will be submitted to the inquiry by the end of today, bringing the total number of documents disclosed to around 6,000 and to a total number of pages of around 33,000. The Home Office has confirmed that it has retrieved and preserved the records of all detainees who were at Brook House in the relevant period, in other words, between April and August of 2017. The inquiry will be asking the Home Office to prioritise disclosure to it of records relating to detainees with whom the inquiry is in contact. The BBC has cooperated with the inquiry in the disclosure of its unbroadcast footage, and we must acknowledge that it has done a huge amount of work on that footage. We understand that the covert recordings made by Callum Tully were made in sections of varying length, not necessarily 6-minute lengths, as I stated in the note that was sent out to all core participants. The BBC is working and has worked on putting those sections together and is prioritising the creation of versions that will show all of the filming on specific days, and in particular those days on which an incident of mistreatment was recorded. We understand that the recordings total around 109 hours. Some of the footage will not be relevant to the inquiry, and a large proportion includes sensitive and personal footage. The very nature of covert filming means that those who are seen and heard on the film are not aware that they're being recorded. People may be seen undressed, or may be heard discussing their medical conditions or other intimate and completely irrelevant personal matters. Irrelevant but very sensitive documents may be caught by the camera. The footage may also show details of locks or other security measures. None of this material, unless it is relevant to the inquiry's work, can be disclosed to core participants or to the wider public. Material that is relevant may require pixelation or audio editing or other forms of redaction. The BBC itself has conducted a very lengthy exercise to highlight the areas of film that may give rise to sensitivity, and also those most likely to contain content relevant to the inquiry's work. The inquiry is working with the BBC to prioritise disclosure of material most likely to be relevant, and in particular, that material relevant to the former detainees with whom the inquiry is in contact. In addition, Sussex Police, the CPS and the Independent Monitoring Board have provided disclosure. Inquiry lawyers have met with Verita, the company responsible for the Lampard report, and have served a Rule 9 request on it. There has been some further correspondence, and Verita's disclosure is being followed up by the inquiry. The process of collation and redaction of all of this material is immensely time-consuming, and it is absolutely imperative that the inquiry gets it right. We have an obligation to protect the privacy of individuals named in documents or shown on film. We owe that obligation to former detainees in particular. The inquiry's intention, as I've mentioned, is to replace with ciphers the names of all detainees wherever those names appear. Insofar as the film is concerned, the inquiry intends, as far as it can, to work with the detainees shown in the footage and consider any representations from them before arranging for onward disclosure. Disclosure to core participants will be arranged in tranches once the redaction process is complete in respect of particular groups of documents. The inquiry is prioritising G4S and Home Office material. It may be possible to give early disclosure to core participants of documents that do not require extensive or indeed any redaction, but this is subject to two matters. Firstly, the inquiry does not want to be distracted from the task of dealing with prioritised material. And secondly, disclosure must be meaningful. There is no point in the inquiry sending out tranches of disparate and unrelated documents, or only part of a set of related documents. But the inquiry is very, very conscious that core participants are keen to see material as soon as possible and will do everything it can to expedite useful disclosure. May I turn now to witness tracing? The inquiry's invitation to former detainees to apply for core participant status led to 3 applications being made, in addition to those that had already been made by and granted to BB and MA. All 3 of the recent applications have been granted, although matters relating to their legal representation still have to be resolved. In addition, the inquiry believes that it knows the identity of 28 individuals who can be seen on the panorama recordings. The inquiry has identified 2 former detainees from a reported judgment in recent litigation, and the Sultani against the Secretary of State for the Home Department. The inquiry is treating this group of 35 former detainees as a priority group. Where we do not already have reliable contact details for them, the inquiry is in the process of instructing tracing agents to assist in finding up-to-date addresses. The Home Office will also be asked to assist and has offered its assistance. The inquiry is very conscious that some former detainees may be suspicious or even frightened to receive official-looking correspondence from the inquiry. For some, the idea of being asked to relive trauma experienced in detention may be distressing or even damaging. Letters to detainees will, as far as we can, be translated into the first language of the recipient where that language is not English, and the letters will contain contact details for support services. The inquiry's hope is that it will be able swiftly to follow up initial contact with the provision of documentary material relating to that former detainee, and with a request for an interview at which a statement can be taken. The intention is that the detainees should understand immediately, or as soon as we possibly can, the reason for which we are contacting them and the material that we have that we want to ask them about. The detainees will, of course, be entitled to legal assistance at public expense. Some core participants have suggested that efforts should have been made earlier to contact detainees, and that wider efforts should be made now to contact a greater group. There are advantages and disadvantages in any strategy for contacting this group of particularly vulnerable witnesses. Because of the risk of causing fear or even real damage to a former detainee through contact, the inquiry wanted firstly to ensure that it was approaching people who were likely to be able to give relevant evidence, and secondly, that the inquiry would be able to engage with them constructively soon after contact was made. This approach required the inquiry to have documentary material in its possession before identifying those to be contacted. This was felt to be preferable to making initial contact and meant not being able to get back properly for weeks or even months. May I turn now to the issue of taking witness statements? The inquiry is currently collating from the various document providers the evidential material relating to this priority group of detainees. The inquiry's plan over the coming weeks is to send to each former detainee with whom we're in contact, or their legal representatives where they have one, a bundle of documentary material relating to that person, and to make arrangements for inquiry staff to take witness statements from each individual. The specific arrangements, including the need for interpreters, will be discussed well in advance with the individual or his lawyers. The sensitivities involved mean that, for obvious reasons, it is very undesirable for the inquiry's contact to be entirely remote, whether that's by letter or telephone or video. We had hoped very much that it would be possible by now to conduct face-to-face interviews. The reality the inquiry has to recognise is that this is likely to be impracticable for the foreseeable future. Inquiry lawyers are willing to meet witnesses in a suitable, socially distanced environment, but the inquiry will respect the wishes of any witness who does not, in the current circumstances, want face-to-face contact. The inquiry plans to obtain as much evidence as possible at an early stage from former detainees so that their accounts can then be put to the GFELT-4S staff, who will then be asked for statements. The inquiry is also treating as a priority the obtaining of a statement from Callum Tully, BBC reporter, and possibly from others who were involved in the making of the Panorama programme. We need full disclosure from the BBC before the inquiry makes a formal request for a statement, and the inquiry is in very constructive dialogue with the BBC about that. Next, I'd like to turn to expert evidence. It is the inquiry's intention to seek expert evidence on, firstly, the extent to which mental health issues of detainees played or may have played a part in the treatment to which detainees were subjected. Secondly, whether Rule 35 processes were properly followed and reports were made appropriately. Thirdly, whether detainees received appropriate medical and in particular mental health care while in detention. Fourthly, whether oversight bodies could have done more to identify any shortcomings in medical and particularly mental health provision. And fifthly, what structures or policies could be put in place in future to identify and act upon any shortcomings. It seems to the Chair that expert evidence is likely to be required from an appropriately experienced GP or an expert in the policies and practices of medical care in the detained environment. It is possible that the same person could fulfil both roles. As core participants are aware, the inquiry has already held preliminary discussions with Dr. Juliette Cohen, Head of Doctors at Freedom from Torture. In addition, the Chair is considering whether to appoint an expert to examine, firstly, the extent to which race, or more specifically race discrimination, may have played a part in the treatment to which detainees were subjected. And secondly, if it did play a part, what steps the Home Office and or contractors should take and what processes and safeguards they should be in place to prevent a recurrence. The inquiry is very grateful for the suggestions already made recently by core participants at this stage as to suitably qualified experts. The inquiry also welcomes the suggestions that have been made in respect of experts in other fields for the Chair to consider. The inquiry would ask that any further recommendations be made by the 9th of October 2020. And at the end of the hearing, subject to any submissions made by any core participants now, I would invite you, Madam, to rule that that deadline should be applied. I will now pause so that core participants can make oral submissions in relation to the appointment of experts. The order in which I suggest that submissions be made is firstly Ms Harrison, Queen's Counsel, on behalf of her core participant clients, then Mr Armstrong on behalf of his core participant clients, then Mr Jaffergy, Mr Blake, Mr Eisenberg, Mr Bunting, Ms Dobbin and Mr Dixie. So may I pause now and ask whether Ms Harrison has any submissions she would like to make on the subject of experts.
We have set out in detail our position on experts in a written letter that I hope that the inquiry obtained should have obtained this morning. Our position is that we would certainly endorse Juliette Cohen as being an independent expert with the appropriate medical expertise, and in addition, which is critically important, deep understanding of how the policies and practices of the Home Office work in respect of vulnerable detainees. And so we would certainly endorse her as an appropriate expert. We would also submit in particular that it is important to have expertise from a suitably qualified consultant psychiatrist who is able to also assist the inquiry on matters that are particularly relevant to MA and others who suffered from mental disorder whilst in detention. And we think that it will be important for the inquiry to have that expertise. as well as to be able to have input on the methods of use of force, restraint, segregation, and control that it is clear are used to manage people with serious mental illness in an inappropriate and abusive way. And again, psychiatric input on the way in which mental illness is treated and managed is going to be important, as well as assisting to understand clearly the impact of those methods on the detainee experience, and whether, as we say, they indicate treatment that crosses the Article 3 threshold for inhuman and degrading treatment. Psychiatrist is going to be of great assistance in respect of that. We do strongly endorse and have repeatedly said that it will be critically important for the inquiry to have expertise from a person with understanding of both the communities that and the people who are subject to immigration control, by definition ethnic minorities who may also be religious minorities, and critically important that they have a keen experience and understanding of institutional discriminatory practices of racism, othering, and dehumanizing that is evident and was identified by the judge who heard the judicial review as being disclosed in the Panorama documentary. So we say that's critically important to the inquiry's work, and we have made individual recommendations. I don't know if you want me to advance who those individuals are, but we've put them in writing.
Madam, I can confirm that the inquiry has received those submissions, and it's probably not necessary, unless Ms Harrison wishes to do so, to go through the names and the reasons for the recommendations.
Well, I'd invite you to read those in full. We'd say those individuals we've proposed have the necessary competence and expertise.
Thank you, I will do so. Thank you.
In addition to that, we do submit that it's necessary and could be of advantage to the inquiry to have input from an expert who understands the contractual arrangements and the procurement process between G4S and the Home Office. We are of the view, from the information that we're aware of, that that can play a critical role in the arrangements that are in place and the policies and practices and how they're implemented. They are underscored by the contractual arrangements and have a significant role to play in what we believe is evidence of systemic failure that led in part to the abuse of MA and others. And we have also made recommendation of an individual who has that kind of expertise that we think will be important, both for understanding the systemic failures that occurred at Brook House, but also in order to make informed recommendations for the future. Those are all the submissions that I make on experts.
Yes, can I check if I can be heard?
You can.
Yes, thank you very much.
Thank
Thank you, Ms McGarhy. Thank you, Chair. Can I just? I'm going to just lend my voice of support to what Ms Harrison has just said, and I'm not going to develop that much more. We've also, I think, you've also had correspondence from those who instruct me, agreeing with the Duncan Lewis letter to which was sent yesterday and to which Ms Harrison has referred. Can I just say this? It doesn't require me to rehearse and reflect on the importance of this inquiry, which is the first of its kind in the difficult area of immigration detention, and which makes it extremely important, prompted by abuse at the highest and most systemic level, reflected in ministerial comment, reflected in what the High Court and indeed the Court of Appeal had to say about it last year. And that requires a particularly intensive examination of a kind, we say, that has not previously taken place. Now, that means in our submission, one needs to go further. And in order to do that, we say the inquiry may need more help than previous investigations have had, and that requirement extends to expert evidence. So if in doubt, we say get experts involved. We'd lent our voice in support to Juliet Cohen, who is obviously qualified, which is no doubt why the inquiry has already approached her. If I need to develop these points, then I will, but we reject the apparent objections that are made in the Home Office's latest submission about her. She is eminently well qualified. She is a doctor who answers to a professional code. The Home Office has not identified anything that she has said publicly or otherwise that might disqualify her from that. They're raising issues of independence with her. There are plenty of people who come from various sides on immigration detention involved in this inquiry, and none of that should disqualify someone of obvious qualifications. I would also support in particular the need, and we say is essential, for an expert on race. That is, just to say something additional about that, is that is a particularly complex, often nuanced and sensitive issue with which we are going to require help in my respectful submission. I know, Chair, that you're aware of the inquest into the death of Prince Fosu, which took place in February this year and was a particularly dramatic example of the failures that can occur in this area. A lot of the evidence in that case touched upon, at least indirectly, race elements, because that was a man from whom everybody walked away. That was a man from whom doctors, detention officers, IMB members, all of them walked away and saw him but did not see him. The overtones behind all of that were treating him as somehow less for whatever reason, and whether that's race, whether that is because he is a migrant, that is whether he is seen as odd because he was demonstrating mental health issues, or for some other reason. All of that was hopelessly wrong, but it did mean that all of the safeguards in that case failed. And it is certainly strongly arguable that something else similar happened here, because the evidence so far disclosed in Panorama and seen in the judicial review is that a number of professionals put aside their obvious professional obligations and did something directly the opposite of what they were required to do. And understanding the reasons for that, and understanding whether race or regarding him as a migrant and somehow less was a part of that is we say, critical, and you would benefit from expert advice in relation to that. We also agree with what's been said about somebody on public procurement. That's something that needs to be properly understood. And can I also just formally lend my support to the suggestion of Mary Bosworth, who's a well-known criminologist and who may be able to assist across two different parts of the evidence that you might need expertise on. So can I just refer specifically to the written comments that are made in the correspondence that you've seen? Unless I can assist further, that's all I want to say on experts.
Thank you. And to you as well, Ms. Harrison. I'm sorry I failed to take myself off mute to say that.
Madam, may I invite Mr. Jafferji to make any submissions he'd like to make?
Thank you, Madam. Can you hear me?
I can hear you. Yes, I can't see you, but I can hear you.
Yeah, I'm not sure why that is. I've checked my video and my video seems to be on. It's telling me I can stop the video, but not that I can start it. So I'm not sure why you can't see me. I apologise for that.
No problem. We can hear you very clearly. Thank you.
Thank you, Madam. Madam, I have read the submissions made on behalf of BB and MA. I've read the letter from Duncan Lewis that was sent to core participants, I think yesterday or this morning. And I've heard the submissions made by my learned friends, Ms. Harrison and Mr. Armstrong. We would adopt all of that and support everything that is said. There is just one short point that we would make in relation to expert evidence, and that relates to expertise in relation to mental health issues and psychiatric expertise. It seems to us, and you will note that my client was granted core participant status relatively recently, so we're relatively new to all the material that is before the inquiry, and we are not fully aware of the circumstances of the other core participants, in particular the former detainees. But the focus seems to be upon existing mental health issues and identifying those at the point of detention and exacerbation of those mental health issues whilst in detention. We would also point out that there ought to be focus on development of mental health issues whilst in detention. What can be learned about that issue, how that can be prevented in the future, and what about the circumstances of detention overall contributes to that. Madam, apart from that, there is nothing else that we would like to say on the issue of expert evidence.
Thank you very much.
Mr. Blake.
Thank you. Can I begin by thanking the inquiry for setting up this remote hearing and for all the work that has gone into making this inquiry possible despite all of the restrictions which have resulted from the COVID-19 pandemic. In terms of experts, the inquiry must be free to select its own experts. On behalf of the Home Office, all that we ask is that the selection of experts complies with the ordinary requirements to be independent and that there's no appearance of bias. We're happy to propose experts by the 9th of October and also to provide any comment on other suggestions for experts. We've made brief representations in writing in respect of Dr. Cohen. We understand that any further representations concerning Dr. Cohen and any others can be filed in writing prior to the 9th of October date. I can address you on the specifics today if you would like, but I'm happy to do so in writing prior to the 9th of October.
Thank you. If you could do so in writing prior to the 9th, that would be very helpful.
I'm grateful. I have no further submissions in that case.
Madam, Mr. Eisenberg.
Thank you, Ms. McGuire. You and the chair will have seen from our written submissions that on the matters of expert evidence, G4S is currently considering the representations that have been made so far and the issues of experts more broadly, and it's probably best for us to address those in writing by the deadline put forward by the chair. Thank you.
Thank you.
Mr. Bunting.
Thank you, Madam. The BBC has no submissions on experts.
Ms. Dobbin.
Thank you, Ms. McGahey. Thank you, Chair. We don't have any submissions to make on this today. Thank you.
And lastly, Mr. Dixie.
Madam, I have no submissions to make on the question of expert evidence.
Thank you.
Madam, may I turn now then to the question of undertakings. The inquiry is grateful for the submissions received from the core participants in respect of the proposed undertakings that could be sought from the Attorney General or the Home Secretary. The core participants know what the issues are, but for those members of the public attending the hearing, I can say that the key questions raised are, firstly, should undertakings be sought at all from the Home Secretary and or the Attorney General at this stage? Those undertakings being in respect of undertakings not to use evidence supplied to this inquiry in any subsequent decision or investigation leading to criminal proceedings or in relation, as far as the Home Secretary is concerned, to immigration matters. If undertakings should be sought, should the undertakings be restricted to natural persons only and not extend to corporate entities? Thirdly, should they be restricted to oral evidence and witness statements taken for inquiry purposes and not to other documents? And finally, should the wording of the Home Secretary's undertaking make clear that it applies to the evidence supplied by detainees only and that it will not apply if the detainee seeks in any immigration application to rely selectively on evidence that he provided to the inquiry? Again, I'll ask core participants to make any oral submissions they wish to make about the proposed undertakings. And with your permission, Madam, I suggest that they're taken in the same order. So starting with Ms. Harrison.
We have obviously also made very detailed submissions in respect of this matter in writing. We would want to make clear from the outset, from the perspective of MA and other detainees who were subject to what has been described as appalling abuse, the possibility of criminal prosecution as the primary mechanism for accountability and punishment for wrongdoing has always been a central concern for Mr. MA and others. The inquiry will be aware that for reasons of institutional failure and incompetence on the part of the police and others, no actual criminal prosecution has taken place in respect of the clearly criminal conduct to which my client, Mr. MA, was subject. That is a matter of grave concern. And it is also an important context for why this inquiry is taking place, at least in part, as a substitute for what ought to have been the state's primary response to evidence of abuse of this gravity, a criminal prosecution and appropriate punishment of perpetrators, both individuals and insofar as there was misfeasance in public office on a wider basis. So we start from that premise when we see wide-ranging applications for undertakings from the Attorney General to inhibit evidence which comes before this inquiry ever being the subject, if appropriate, of a criminal investigation. We say that one has to start from the proposition that giving such, seeking and the giving of such undertakings must be in the most limited and confined circumstances, recognizing that there are a number of important public interests at stake when such undertakings are given. First and foremost, as I've indicated, the need to ensure that those who have committed wrongdoing are held accountable. It would be wrong and send out the wrong message to the public that any criminal conduct is being either not properly investigated or condoned by the giving of such undertakings. And of course, we say what's critically important is that if individuals, and in particular individuals who have roles within public authorities where their responsibility and obligations is to provide a lawful, safe environment for those that they subject to administrative detention, are seeking to indicate that they will not be prepared to cooperate without such undertaking, that should be done in public and clearly. So for those reasons, we have suggested to the inquiry that rather than giving at this stage wide-ranging blanket undertakings, the appropriate course to take is a staged one, that only when it is actually demonstrated to be necessary and individuals have sought it with explanation, should the inquiry undertake that process of seeking the Attorney General's undertaking. We, of course, recognise that the right against self-incrimination is an important right and that it is both a common law protection and reflected in section 22 of the Inquiries Act. We, of course, also recognise, because again, it was part of the reason why this inquiry was necessary with its powers to compel the presence of witnesses and documents, that there may well be individuals, particularly the perpetrators of abuse, who've refused to cooperate effectively with police investigations and other investigations, who may well seek such an undertaking. But we say those individuals should be expected to ask for it on an individual basis, and that the form of undertakings that are being proposed at the moment are too wide. We do say that if they are to be sought at this stage, then it is important that they are confined to natural persons and don't cover legal or corporate entities. We see from the submissions that are made by G4S in particular, wishing to endorse the inclusion of legal persons, and and relying on the fact that those have recently been made in the Grenfell Tower inquiry. However, what's significant about that is that that inquiry took it as a staged process, so they weren't made at the outset. There has been a specific detailed basis upon which the undertakings were extended to legal persons, which has not been developed in any way, shape or form by G4S at this stage, precisely because no real process, well, not one that's transparent to us in any event, has taken place in terms of documents. And so they're seeking this on a preemptive basis. We respectfully submit that the inquiry should not extend to legal persons, and we certainly submit that it should not extend to public authorities, including G4S, insofar as it was exercising public law functions in providing detention facilities and services. In Grenfell, those legal persons do not include public authorities, including the local authorities, despite their obviously being in a situation where their culpability for the consequences may be an issue. And so we do say that it's important for any undertakings to be limited to natural persons, and that it is also limited to the witness evidence and or material that's produced in witness statements or in preparation of witness statements is the only material that's covered. Again, we submit that if it's extended in the way that is sought by G4S to all documents, then it has the potential to be disproportionate and excessive and unnecessary. Clearly, public authorities are under a duty of candour. In other proceedings, they would have to produce documents. There's no reason why this inquiry should have special extended protections for documents. And again, it needs at this stage to see if that's really a difficulty rather than a preemptive order undertaking at this stage. One should expect, and certainly publicly, both the Home Office and G4S have said that they will wish to cooperate fully with the inquiry, and that should first of all be taken at its word, rather than seeking now to prevent any material that come in a documentary form ever being made available if it were a possibility for criminal prosecution. Finally, in terms of the further extension that G4S have recently indicated that they would wish to seek based on lines of inquiry, that was only put in writing yesterday. What's relied upon there in support of that is that it was an undertaking that was given in the Baha Musa inquiry. We haven't, in the time available, been able to fully research that. That was obviously an extensive inquiry that took place over a number of a protracted period. It would be important to see at what stage such additional undertakings were agreed and why. And again, effectively, we say that this would cover virtually all forms of material that came into the inquiry's possession and have an inappropriate and disproportionate impact on the possibility of material subsequently being relevant to criminal proceedings. And again, we say what is necessary is not a blanket request at an early stage, but a detailed one that actually is based on identifiable particular need arising, if it ever does, for such an extensive undertaking to be sought and given. So in summary, we say it's not necessary to give those to seek those undertakings now. If it is, then it should be limited to natural persons and oral evidence and witness statement evidence only. Those are my submissions.
Thank you, Ms Harrison.
Madam, may I invite Mr Armstrong to make submissions next?
Thank you, Chair. Can I again align myself with everything that Ms Harrison has just said? Can I just start with this, though? We are in large part responding to submissions that were made by G4S and partly the Home Office, but also G4S. And can I just note with some regret the fact that the G4S submissions were received late on Wednesday night, which was a spectacular 3 weeks after the deadline that the chair set. We hope, able to deal with that, but that was done without apology or explanation on the part of G4S. And putting it gently, we would have thought that G4S, of all organisations involved in this inquiry, were the one most anxious to be compliant and apologise or explain if they're not able to be compliant. I don't know if the chair has heard anything about that, but we, the other core participants, certainly have not.
And perhaps I can assist in that if Mr Johnson would like me to do so. G4S's counsel was elevated to the bench, and so it required a change of team. That was the explanation we were given. Well,
I'm grateful for that. It's still a long period of time and makes life difficult if it's that late. Can I associate myself in particular with the importance of public accountability? That's critical, and criminal accountability is particularly critical, as Ms Harrison has said. The reason why we have said, and we emphasised in particular in our written submission, the point of staged staged undertaking, and don't require it first, but then and instead require anybody who wants it to ask for it, is precisely, and it's a similar approach to what was taken in Grenfell, where there was no undertaking asked for at the start, is to flush out the individuals who want it and ask them to explain why they want it. And that is an important thing to do in order to explain why they should not be accountable in that particular way, and understand who it is who is doing it, and apply a threshold to such a request by making them do it, and do it in the course of the public inquiry. We say that that is all the more important where at the moment the undertakings extend to not just natural persons but legal persons, because the obvious organisation to whom that applies is G4S. And G4S have gone out of its way in response firstly to Panorama and secondly to the Lampard investigation which it commissioned, to say that it is very concerned about all of these matters. It completely accepts in an unqualified way everything that Kate Lampard said about it and will comply with those recommendations. If it is now saying, as it appears to be saying, that it may not want to do this, it may not fully cooperate because it may not be able to fully, it doesn't particularly want to fully cooperate without an undertaking, then G4S ought to be asked to say that, say it clearly and explain why. So that is why we say a staged approach should be taken, and that's also linked to why we say that there ought to be a distinction between natural persons and legal persons. I understand, by the way, that there was a discussion in Grenfell, I wasn't there, but I understand that there was a discussion in Grenfell about the legal and natural distinction, and it wasn't adopted in Grenfell. But the reason why it wasn't adopted in Grenfell was because of the large number of small companies that were involved there that made it impossible to draw that distinction. But that is not true of G4S. The other point I should make also is that if legal persons are to be covered by this, then it absolutely should cover their witness evidence only and not documents. In particular, pre-existing documents. I mean, my understanding is that all the G4S material is in any event. None of that should be caught by, none of the documents should be caught by an undertaking. That's all I want to say about the Attorney General undertaking. Can I just deal briefly with the Home Secretary undertaking, which we support? The position of the potential victims, the position of the potential victims is different to the position of G4S or Home Office employees. That is because, just one moment, can I just stop a bit of banging that's going on behind me? Thank you. It is those individuals will have much more cause to be nervous about coming forward, and will be, as the chair will no doubt understand, much more vulnerable. And what is important for them is that the protection should be broad, and it is vital that it's broad and also capable of being understood in order to be effective. And I make that point because if some of what the Home Office is saying, Mr. Blake has said in his submission, is that there ought to be qualifications to this and additions and circumstances in which the Home Office might be able to put in evidence in response if things are being misrepresented or contextualized, or contextualization is required. This ought to cover anything that is produced by somebody before the inquiry. If the Home Office produces it, that is not covered by the undertaking. It's not just for detainees or former detainees. It might also be the subject of people who are migrants. There may be circumstances in which you have a migrant who is concerned about this, but who was not detained. That too ought to be covered by the undertaking. I also say the line of inquiry submission that is made in respect of G4S must be true in the Home Secretary undertaking context, because if somebody is going to be, if there is going to be evidence caused or obtained as a result of something that somebody has said, then that will need to be protected as well. And finally, my final submission in relation to this is on the fourth point, which the Home Office make in their submission, which is where they talk about the idea that a migrant might be before the tribunal or in some other kind of proceedings and may say something about their own evidence which misrepresents the position. My submission about that is a problem that is very unlikely to arise. It's a speculative submission made by the Home Office. If that was to arise in tribunal proceedings, the idea that a Home Office presenting officer would be in a position to deal with it on the fly is very unlikely. But in the unlikely event that something like that arose, we say that the correct answer to that would be to apply to have that undertaking discharged, not to not have the undertaking in the first place, or to have a qualified undertaking in the first place. So those are all my submissions in relation to that. The Attorney General's undertaking ought not to be sought, and there ought to be a staged approach where people ask for it rather than having it automatically. The Home Secretary undertaking is required for obvious reasons, but those need to be simple and clear and unqualified in order to be properly understood and therefore effective for the purpose that you want for them, which is to encourage people to come forward and be fulsome in their evidence and open in their evidence and unfearful in their evidence. Unless I can assist further, those are my submissions.
Thank you, Mr. Armstrong.
Mr. Jafferty.
Thank you, Madam. Madam, I adopt the submissions made on behalf of MA and BB. I have nothing to add.
Thank you.
Mr. Blake.
Thank you, Madam. Our position is that, like with the issue of experts, if the inquiry considers that it needs undertakings, we are supportive of the requests being made to the Attorney General and to the Home Secretary. On the Attorney General undertaking, in our submission, it's sensible to seek those undertakings now so as to avoid any last-minute derailing of the timetable. Everybody is united in wanting to avoid delay in this inquiry. The wording that the inquiry has proposed quite clearly follows a great deal of thought on the issue, including the issue of whether it should include both natural and legal persons, and we certainly don't seek to interfere with that proposed wording. As G4S identify in their written submissions, there was an instance in the Grenfell Tower inquiry where the inquiry had to go back to the Attorney General to seek a wider undertaking. I don't believe it was an intentionally staged process. I think circumstances just called for that extension, and that should be avoided if possible, purely for a timing perspective. On the Home Secretary's undertaking, I make clear that although I represent the Home Office today, the decision as to whether to grant an undertaking and in what form will be an independent decision for the Secretary of State, and it's important to keep that separation. It wouldn't be right for me today to make submissions on the wording, other than to point out, as we already have in correspondence, the difficulties that may arise with the current wording. But once again, the wording that's been proposed by the inquiry is clearly the result of a great deal of thinking on the issue. All we suggest at this stage is to seek to avoid any misunderstanding or misuse of the undertaking, and ask that any proposed undertaking makes very clear who it applies to, makes clear what it applies to, and is worded in such a way that it can't be misused to one party's advantage, whether that is by some sort of discharge provision, as suggested by Mr. Armstrong, or by way of some other clarification. In other words, all we ask for is that the proposed form of words that is sent to the Secretary of State is clear and is fair. Apart from that, I have no further submissions.
Thank you, Mr. Blake.
Mr. Eisenberg.
Thank you. G4S agrees that it's appropriate for the Chair to seek undertakings from the Attorney General and indeed from the Home Secretary at this stage, so as to avoid potentially significant and prejudicial delays further down the line, especially in light of the understandable desire for timely progress sought by the core participants. The alternative, the staged approach primarily sought by the detainee core participants, BB and MA, we say is not the appropriate approach to take. And in my submissions, I'll deal firstly why we say the undertaking should be sought now from the Attorney General, and then I'll go on to deal with the second issue of the scope of the undertaking. The key, we say, to why the staged approach is inappropriate in these circumstances is the need for the inquiry to progress in an orderly, predictable and efficient manner. And the important context to this are the other core participants' concerns, quite understandable ones, about delay. And even if the inquiry sets down a timetable now, there can be quite disproportionate delays if that timetable has to be subsequently amended, potentially late in the day, by reason of applications and correspondence relating to undertakings, especially when this could occur more than once. The staged approach appears to suggest that the inquiry should essentially wait for a person to invoke the privilege against self-incrimination or the use of Section 22 of the Inquiries Act, and at that stage potentially seek an undertaking from the Attorney General. The problem with that approach is that it allows for the potential for significant delays, as the process could even be an iterative one. So say, for example, you have witness X who seeks to rely on the privilege against self-incrimination at one point during the evidence gathering process. There is then a protracted period of correspondence, submissions, and maybe even a hearing dealing with the potential for an undertaking to be sought in relation to the issues raised by witness X and to those in a similar position. An undertaking may then be sought from a given time from the Attorney General. It may then be that a month later, witness Y or core participant Z refuses to produce a document on grounds of the privilege against self-incrimination. There could be a further round of correspondence and submissions with a hearing in respect of whether the first undertaking ought to be extended to cover, for example, documents or legal persons, issues that weren't previously considered when the first undertaking was sought and provided. All of this, we say, militates towards dealing with the issue comprehensively at this stage. Just dealing then with some of the points raised in the submissions by BB and MA on this. It's suggested that seeking an undertaking at this point could render accountability through the criminal courts less likely. However, that is not, we say, an accurate characterization. The essence to the undertaking is that it does not go further than the scope of privilege against self-incrimination as reflected in Section 22 of the Inquiries Act. So an undertaking thus does not render prosecution less likely, where it goes no further than to cover material or evidence in respect of which a person could and likely would refuse to produce by virtue of the privilege. BB suggests that the public interest balance falls differently in respect of the undertaking to be sought from the Attorney General than that proposed to be sought from the Home Secretary, which BB agrees should be sought at this stage. But the crucial difference between the two forms of undertaking is that the relevant witnesses could always rely, in respect of the Attorney General's undertaking, could always rely on the privilege against self-incrimination or on Section 22. That undertaking goes no wider than to cover material that the person could in any event refuse to produce. However, that consideration does not apply to the Home Secretary undertaking because the privilege against self-incrimination does not apply to material which is adverse to, for example, a potential immigration decision. And so we say it's even more appropriate at this stage that the undertaking should be sought from the Attorney General, if indeed it's to be sought at this stage from the Home Secretary. It's also suggested by BB that there is a specific public interest in having the relevant witnesses or the core participants kind of quote unquote put their cards on the table by asserting the privilege against self-incrimination before an undertaking is sought, and that to do so would prevent a person from publicly stating that they are fully cooperating when in truth they are only doing so by reason of an undertaking. Now, insofar as there is any true public interest in this, as BB asserts, it, we say, is limited. And in any event, as MA recognises, the privilege against self-incrimination is likely to be adopted by at least some witnesses. And the privilege is a fundamental right, and no adverse inference could or should be drawn against a person relying on it. In any event, we say, any limited benefits, as identified in this way, is heavily outweighed by the likely delays to be caused by adopting the staged approach. Indeed, BB's pointed to Grenfell as a precedent for the staged approach, but that example should actually be a warning note for this inquiry, given that it caused material delays to that inquiry, given the timings and manner in which the undertakings were sought and indeed extended from the Attorney General. Moving on then to the scope of the undertaking to be sought. Now, we have provided draft wording appended to our written submissions, which I would invite the chair to consider, and those are marked up against we've marked up there the proposed amendments to the chair's original draft. And there are three key points on the scope of the undertaking that I'd like to draw out. First is that they ought to cover both legal and natural persons. Secondly, that they apply to both documents as well as oral evidence. And thirdly, that they should apply to what we have termed the line of inquiry undertaking, the derivative evidence. Dealing firstly then with legal and natural persons, BB suggests that there is no basis for seeking an undertaking in relation to legal persons at this stage. But again, we say this falls into the trap of seeking a staged approach by the back door, which is likely to cause further delays further down the line, as I've already set out. In any event, it creates an artificial and an unjustified distinction. Once it is considered appropriate to seek an undertaking, it is then unjustified to seek that it apply only to natural and not to legal persons. The touchstone here remains ensuring that all relevant information is before the inquiry and that the privilege against self-incrimination does not prevent that from taking place. Legal persons are just as entitled to rely on that privilege as natural persons are, and thus the justification for including them within the scope of the undertaking is the same. And it's not enough that the relevant legal persons here are organisations providing services to the public to upset that public interest balance. Secondly, then, to the inclusion of documents within the scope of the undertaking, not just to oral evidence and the associated written statements. Again, we say the touchstone is the privilege against self-incrimination. That privilege covers not just oral evidence, but also the provision of documentation. And were documents to be omitted from the undertaking sought, that would leave a category of relevant material outside of the undertaking, but in respect of which the privilege could be asserted. Thus, the narrower the undertaking sought at this stage, the greater the likelihood that the privilege will be invoked, and that time will be taken further down the line dealing with whether the chair should seek that the undertaking from the Attorney General be extended to include documentation. MA seeks reliance on the approach again taken in Grenfell and refers to the fact that following extensive arguments, Sir Martin Morbick sought an undertaking limited to oral evidence only. I should point out, however, that the application made in that inquiry was only for an undertaking covering oral evidence. It was not in that case sought that a document undertaking should also be provided, and that was refused. So we say that no such reliance can be placed on Grenfell. And in fact, looking at properly comparable cases, for example, the undercover policing inquiry, Azelle Rodney, those were cases, inquiries in which the relevant undertaking did cover documentation. Finally, then, what we've termed the line of inquiry element of the undertaking, that it should extend to prosecutions not just reliant on documents and evidence directly produced to this inquiry, but also produced by an investigation that has itself been commenced as a result of evidence provided to the inquiry, i.e. derivative evidence. Now, we take as our starting point the chair's own notes that witnesses to this inquiry should be able to give evidence freely without the fear that doing so might lead to criminal investigation. And the key point there is investigation. It's not just prosecution reliant on evidence given to the inquiry directly, but further criminal investigation. And to that end, we have proposed the undertaking covers what we have termed this line of inquiry evidence, and I direct the chair to consider our written submissions on this point, which are at paragraph 11C of those submissions. This is about ensuring the witnesses give a full and frank account, and crucially, that it goes no further than the scope of the privilege against self-incrimination. See again our reference to the Al-Swedi inquiry on this point, which made clear that the line of inquiry element of the undertaking falls within the scope of the privilege against self-incrimination. And this element of the undertaking has already been used in materially similar inquiries, both Baha Musa and also in Al-Swedi, as well as the others referred to in our notes. So this is not in truth an extension, but rather it's ensuring that the undertaking sought mirrors the scope of the privilege against self-incrimination on the same basis that I set out before. The wider the gap between the undertaking and the privilege, the greater the likelihood for applications and delays to the timetable in due course. Now, MA has submitted that there is to be no prosecution in his case, and thus the inquiry is the only means by which he may vindicate his entitlement to factual findings. And it is therefore precisely for this reason that the inquiry needs to be confident that it will obtain all relevant material. And to do that, it requires an undertaking from the Attorney General, so far as is possible, coextensive with the privilege against self-incrimination. And unless I can assist further, those are my submissions on the undertakings.
Thank you, Mr. Eisenberg.
Mr. Bunting.
Madam, no submissions from the BBC on this point either.
Ms. Dobbin.
Madam Chair, we don't have any submissions to make on this point. Thank you.
Mr. Dixie.
No submissions, thank you.
Madam, may I go on now to address the proposed timetable? You have already submissions about the delays that have occurred in this inquiry. There is, in my submission, very little to be gained at this stage by having a detailed day-by-day analysis of the difficulties that this inquiry has suffered in the past. However, it is important that the public should know what has happened, so I can provide a brief summary. The inquiry was established in November 2019. The Home Office had to set a budget for it and was also responsible for putting in place the inquiry's computer system and the document management system, and for obtaining premises for the inquiry. And I should halt there to say that the branch of the Home Office responsible for making this provision is not the branch of the Home Office represented today by Mr. Dixie. There is, and always is, when the Home Office is a sponsoring unit, a Chinese wall between the sponsorship unit and the Home Secretary as a participant in any inquiry. But of those resources, the key element for the inquiry was the document management system, because without it, it was absolutely impossible for us to process the thousands of documents that we knew would be made available to us. And while we could, and we did, in advance, prepare Rule 9 letters, the letters requesting individuals or corporate bodies to provide material to us. It wasn't possible for us actually to send those letters out and to ask for material until we were confident that we had somewhere secure to receive it and store it. We did send out, in fact, the first Rule 9 letters in the spring in the anticipation that we would very shortly have a working document management system. As it turned out, the systems were not properly in place until the summer. But in any event, at the point at which we sent the letters out, the COVID-19 lockdown was put in place. That meant that many providers who would have collated and disclosed documents with whom we had been in discussion and from whom we expected cooperation had to send their staff home, and their access to the material was lost. There is also a further element which is relevant to the pandemic. The inquiry believes that it is really important that the oral evidence hearings should, when they take place, be in-person hearings if that can at all in practice be achieved. The inquiry has at all times envisaged a timetable that will allow for such hearings. There's a number of reasons for this. Firstly, it is likely that some witnesses will need an interpreter. It is also likely that other witnesses will face criticism and others will be asked to explain behaviour that, just on the basis of the panorama footage, looks utterly indefensible. Although it's not impossible, and we recognise we may have to do it, it is difficult to hear remote evidence with the use of an interpreter. And it is also, the inquiry believes, very undesirable, although again, not impossible, to deal remotely with evidence that will be subject of very vigorous challenge. For these reasons, the Chair has reached the provisional view that the oral evidence hearings should be timetabled to begin next summer, not before mid-June, that the inquiry will not sit in August and that it will continue as needed in September 2021. While the delay is not something anybody would have wanted, a hearing in the summer of 2021 should give everyone enough time to prepare and also enable the inquiry to determine whether in-person hearings will actually be possible or whether virtual hearings have to be arranged. Allowing this amount of time will also allow for the difficulties that the inquiry is now bound to face in seeing witnesses and obtaining material in the light of the COVID restrictions that it appears are going to continue for the next few months. The risk of setting an earlier date for that final hearing, however tempting it may be, is that it causes inconvenience to absolutely everybody if it then has to be moved. And the experience of other inquiries really demonstrates that, because many inquiries that were already up and running and had planned hearing dates had to abandon those dates, move them all on until restrictions seemed to be reduced or until they had learned to cope with the restrictions, with the result that many people who had planned their diaries were no longer able to attend them. So while the reality of this proposal is that it will mean that any report is unlikely to be produced before 2022, it does seem obviously preferable to hold a thorough inquiry and take the time to do it properly than to undertaking a faster but less comprehensive investigation. Clearly, one matter that has to be resolved before one looks in great detail at timetable between now and June of 2021 is the question of the resolution of scope of the inquiry. I will come back to it in more detail, but I can say at this point that the Chair has decided that a hearing on scope will take place on the 30th of November of this year. I'll pause now to invite core participants to make submissions on the proposed timetable, with a particular focus on the plan to hold the substantive hearing from mid-June of next year. So could I turn to Ms. Harrison, please?
Yeah. On behalf of MA and others who I represent, it's important to put the delay in the context of the legal obligations that are attendant upon an Article 3 compliant investigation. A critical aspect of such an Article 3 compliant investigation is that it is prompt, and it has to be a prompt response by the authorities, because that's recognised as being essential in maintaining public confidence in the adherence to the rule of law and in preventing any appearance of collusion or tolerance of unlawful acts. Those are words that were quoted by Mrs. Justice May in her judgment in the Judicial Review at paragraph 44. So we do have to put on record that 3 years after these, what are accepted to be appalling incidents of abuse and mistreatment became public knowledge, although MA himself had raised them already in a judicial review, at least some of them in June 2017, that we are still only at these very preliminary stages of this inquiry is plainly unacceptable. And we put on record, as we've done in writing, that in our view, there is a continuing breach of the obligations under Article 3. That context, which it was in large measure a result of intransigence and opposition from the Home Office to any effective independent investigation, does mean that the inquiry had a particular important and heavy responsibility to act speedily and effectively in getting this inquiry up and running. And by admission and acceptance, it has failed to do so. Insofar as it continues to contribute to the failure to comply with the duty of promptness as an important aspect of the Article 3 obligations, then it too bears responsibility. We have sought over a number of months explanation. The absence of explanation and until very recently has contributed to undermining the confidence of MA and others in the ability of this inquiry to operate effectively and to carry out its important function. And the inquiry should be under no illusions as to how disappointing and dispiriting that this delay and lack of communication has been. We see that things have begun to change, and that's welcome, but it doesn't mean that the delay and lack of communication was acceptable when it occurred. So in that context then, we of course are concerned that the inquiry is now planning such a timetable that would mean that we do not have oral hearings until June of next year. We recognise and we endorse, however, that it is critically important that this inquiry does do its work in public in the way in which it was anticipated, public hearings being a central part of the effectiveness of the Article 3 investigation, and as a key role in terms of holding public authorities and those responsible for the abuse that occurred to account, to demonstrate public objection to such conduct, and of course, as was identified by the judge in the judicial review proceedings, to provide to MA and others the ability to confront abusers on an equal basis and to do so publicly is an important aspect of the restorative function that this inquiry can have in returning to him his human dignity and self-respect that was taken away by the abusive treatment to which he was subject. So in those circumstances, MA cannot disagree that we have to find a timetable that is best able to accommodate the ability to hold in public hearings. And in those circumstances, albeit with regret and reluctance, we do not object to the timetable that's proposed at the dates. What we do, however, request, and in order to avoid repetition of the experience that we have had for the past year, is that there needs to be a detailed timetable for steps to be taken in building up to the oral hearings, so that there are regular directions and hearings such as this, that we do have dates penciled in where we can for further preliminary hearings and for matters relating to disclosure, provision of witness lists and other preparatory matters. Only that kind of involvement is going to begin to remedy the deficit in core participation in the inquiry to date. We have sought on numerous occasions through correspondence that was largely unanswered for many months, attempts to effectively pursue a timetable that that was going to be both speedy and effective, and have been deeply concerned. And again, our confidence in the inquiry to some extent undermined by the unwillingness or the failure to respond to our suggestions for how progress could be made. And we would very much hope that any timetabling that takes place now is detailed and staged, so that we all are aware of when the progress is being made and so that we can have a effective contribution to how the inquiry is conducted going forward. And in that context, although it's not a matter that the inquiry wishes to address today, we do say effective funding for the core participants is a key element of making their role useful and effective. And whilst we note from the correspondence that it's indicated that should be dealt with by way of written submissions, in our respectful submission, that's not adequate. The question of effective representation and effective funding for that representation is a matter, as is clear from the judgment of Mrs. Justice May, that is an essential element of an effective Article 3 investigation. And we would ask that going forward, and on the 30th of November, if that's a date now set aside to deal with scope, that we also have an opportunity at that point to make submissions on the way in which the question of participation through legal representation properly funded has been addressed so far and will be addressed in the future, in line with what timetabling, detailed timetabling, we hope the inquiry will see fit to put forward, if not at least by the 30th of November. Those are my submissions.
Thank you, Ms. Harrison.
Madam Mayor, I invite Mr. Armstrong to make submissions.
Yes, thank you. I'll be very brief on this aspect. Can I agree again with what Ms. Harrison says about the delay thus far, but emphasise not just the delay, but the absence of communication about delay. Of course, the pandemic circumstances are exceptional, but participation in the process is absolutely key to the fairness of a process and the feeling of fairness in a process. And the detainees in particular, but all those who we represent, need to feel that they are participating so that they can feel that they're being heard and that they are influencing. And if we don't know what is going on, then they don't feel that way. I'll extend that agreement with Ms. Harrison to the issue of funding. I know it's not an issue for today, but it is an extremely serious issue. And I do want to just sound publicly that the participation needs to be funded. There is a great deal of frustration on our side about the absence of frustration, about the absence of funding, and about the amount of time that is having to be spent, particularly by DPG and Duncan Lewis, about the absence of the funding. It's taking up an enormous amount of time, and it is affecting. It is taking up the effectiveness. It impacts upon the effectiveness of it, and it impacts upon the impression that those participating or wanting to participate have. Now, We are, however, where we are. For our part, we think that June 2021 is probably inevitable. For our part, we are minded to agree with what has been said by Ms McGarhy about the importance of in-person hearings. You will have noticed a comment in Mrs Justice May's judgment about confronting and the importance in Article 3 purposes of confronting. You can't, I'm afraid, do full confronting and full effective analysis of what's happened in this case in this way. It doesn't work in the same way. I think those of us who've been doing this for 6 months will all say the same thing. So we do agree with the emphasis on in-person hearing if they can be done. And we suspect that June 2021 is probably inevitable for that reason. However, 2 points about that. Firstly, if it is going to be June 2021, it needs to be June 2021. So we would invite you to manage hard towards June 2021 in order to make sure we don't get there and then miss it. The second point is just bear in mind, it does, on our limited experience so far, appear to be more likely to be effective to have hearings, bearing in mind the pandemic, in the summer than it is in the autumn. Conditions seem to be better in the summer than they are in the autumn. I'd just keep that in mind on the basis of our experience so far. That's all I want to say on timetabling.
Thank you, Mr Armstrong.
Mr Jafferty.
Thank you, Madam. I again adopt the submissions made by my learned friends, Ms Harrison and Mr Armstrong. I have nothing to add.
Mr Blake.
Thank you. As I noted at the beginning, a great deal of work has gone into the inquiry. The setting up of a statutory inquiry in the early stages aren't simple, and it may be difficult to appreciate this if you're not on the end of a disclosure request. And obviously the Home Office have been working very hard, providing a great deal of documents to the inquiry pursuant to their request. Looking at the future rather than the past, no doubt the inquiry will take quite a bit of time reading the many thousands of documents, tens of thousands of pages that have been disclosed. And in light of that and the next steps, which are disclosure to other core participants and the taking of witness statements, the timetable that has been proposed, we think is realistic. As far as the November hearing is concerned, I would ask the inquiry considers the dates of core participant availability, and that the 30th of November isn't necessarily fixed without at least some consideration of accommodating as many people as possible, if at all possible. I have no further submissions to make. Thank you.
Mr Eisenberg.
Thank you. I would just first like to echo Mr Blake's submissions in terms of the hard work that's been done so far, both by the inquiry's own staff as well as those managing document production, both by the Home Office and also by G4S. Counsel to the inquiry has already noted the large volume of documentation that's been produced, and a lot of kind of hard work and hours has gone into that. In terms of the next steps going forward, you'll have seen from our written submissions that we agree that the next summer 2021, is the appropriate time for oral hearings. And in fact, given the recent announcements in terms of the move towards more pandemic-related restrictions and what may come over the coming months, starting actually perhaps slightly later in early July rather than mid-June, albeit a small adjustment, may build in a little bit more breathing space to the timetable in light of possible coronavirus restrictions. But we agree summer 2021 is the appropriate time for oral hearings. I have no further submissions to make on the point.
Thank you. Mr Bunting.
Madam, thank you for the update. The BBC has no submissions on this point.
Ms Dobbin.
Yes, Madam, we have no submissions or observations to make either. Thank you.
Mr Dixie.
Madam, likewise, no submissions.
Could I just make one comment about the date? And I would echo what Mr Blake says. I know from my own diary, I've been reminded by Miss Lou that in fact I have a commitment on the 30th of November that I know that I won't be able to get out of. It's a Supreme Court appeal. So I think that will be necessary to liaise. Although ultimately it's obviously important that we get dates into people's diaries as soon as we can. And can I just remind the inquiry that it was the position that this inquiry would be concluded within 12 months. So all evidence would have been taken within 6 months, and the inquiry would have itself have included within 12 months. When we are now told that all reasonable steps have been taken and there has been cooperation, that clearly couldn't sit with the idea that this was going to be resolved within 12 months, which is what was the indication when the inquiry was announced.
Madam, dealing with the points just raised by Ms. Harrison, my own view is that 12 months would have been quite extraordinarily optimistic had there been no pandemic and even no delays, simply bearing in mind the volume of documentation and the number of witnesses who might be involved in this inquiry. On the question of the date, certainly the inquiry is more than willing to liaise with core participants. And my suggestion would be that the inquiry puts forward within the next day or so, the early part of next week, a number of dates. And we would ask people to get back to us, say, by the end of next week. And I will explain now a little more about the inquiry's proposals in relation to the scope of the inquiry, which will explain to the participants why we came to the date that we did. Detailed written submissions have been made about the scope of the inquiry by a number of core participants. It was obvious to everybody that there was not going to be enough time to deal with those this afternoon. Also, it was clearly preferable that the chair should determine at any extent applications for core participant status before receiving submissions on scope, because it's a key issue and it's obviously really important that anyone who's going to be a core participant, whether individual or an organisation, should have the opportunity to make submissions on the issue. Therefore, anybody who's granted core participant status as a result of the applications made today needs to be in a position to make submissions on scope. The reason for suggesting the 30th of November was that the inquiry worked on this proposed timetable, and Madam, the dates that I'm about to give are the ones that I would invite you to direct be followed. That first of all, the existing core participants make submissions on experts by the 9th of October. That does mean, and is very likely to mean, that any core participant who's made a core participant after today's hearing will not be able to comply with that timetable. There may be some flexibility there. The chair will then make decisions on today's core participant applications by the 9th of October. Those submissions have a relevance to the issue of the legal representation of SR, KK and IA. I would invite the chair to direct that any further submissions on that issue by SR, KK and IA should be made by the 16th of October. And Madam, that you then make a decision on representation by the 23rd of October. Written submissions on scope and the interpretation of the terms of reference should then be made by all core participants by the 9th of November, with the proposal for a hearing on scope on the 30th of November. And as I've indicated, the inquiry is willing to be flexible on that date, but it will be unlikely that it can be moved very much further forward, because all core participants and indeed counsel to the inquiry need the opportunity to consider their submissions, make them, and for those written submissions to be taken into account before a hearing takes place. So, Madam, the only outstanding issue now for this afternoon's hearing is the renewed application for core participant status. I'm very conscious of the time and also of the fact that many participants to this hearing do not need to be involved in that, in these applications. Of course, everybody who is currently on the Zoom call or watching on YouTube is more than welcome to stay to listen, because this is a public hearing. But my proposal would be, Madam, that you make the rulings on the dates that I have indicated, and that we then take a short break of perhaps 10 minutes. Anybody who wishes to leave the call can then do so. And that after the break, you hear applications for call participant status from bail for immigration detainees, detention action, inquest and medical justice. And if it assists people in the management of their timings this afternoon, it's anticipated that we'll need about an hour and a half to deal with those applications. So this hearing should finish somewhere in the region of 5:30 tonight, or a little bit later.
Thank you. Thank you, Ms McGahey. I'm very happy to rule on those dates. As you suggest, that sounds very sensible. I also suggest that we will confirm those dates. I'll ask the solicitor to the inquiry, Alice Pennell, to circulate confirmation of those dates to call participants at the beginning of next week. And as you said, very happy to have conversations to try and ensure that we can meet people's availability as much as is possible. But as you say, I think doing it before the 30th of November will not be possible. So we will seek to do it as soon after that as we can. I suggest, as you say, that we now take a 15-minute break so that we reconvene at 4:15, and anybody who does not wish to continue to participate on the call in respect of the call participant applications can take that opportunity to leave. Thank you all very much for the submissions that I've heard so far at this hearing. I want to reassure you that I will carefully consider all of the points that have been made. It remains just to say thank you very much for those who are going to be leaving the call at this point, and we shall reconvene at 4:15. Thank you very much.
Videos off.
Welcome back, everybody. Let's dive straight back into it. If I could ask you, Ms. McGahey, to turn to our third item, which is the renewed applications for core participant status, please.
Certainly, Madam. First, I should correct something I said earlier. I said that the Home Office was represented by Mr. Dixie. I apologise. That Home Office is, of course, represented this afternoon by Mr. Blake and Ms. Wilston. Mr. Dixie represents the IMB. Madam, may I ask you to turn to the last item on the agenda, which is the renewed applications for core participant status from 4 applicants. Mr. Armstrong represents the first 3, so may I invite him to make the first submissions?
Yes, thank you, Ms. McGahey. Chair, I'm going to try to be long. I'm going to try to be short about this. I know that there's already been extensive written submissions. I adopt all of those. I'm obviously representing bid, detention action and inquest. I know that all 3 of them are well known to you. I'm going to assume quite a high degree of knowledge about the background, and it's all set out in writing in any event. I'm going to address them in that order, but before I do, can I just make some general points? One is just on the law, and I know you know what it is, but just by way of emphasis. The purpose of Rule 5 is to allow those directly concerned with or intimately involved with the work of the inquiry to participate effectively, and I emphasise effectively, and assist you in your inquiry. And that is what they are all 3 seeking to do. The way Rule 5 breaks that down is as alternatives. So you have those with a direct and significant role to the matters. Now, the direct and significant role obviously heightens that threshold slightly, but there is then which relates to the matters, and that obviously softens it again. So my submission is that it's not high threshold, but then you have the alternative B, which is significant interest, and you have accepted that all 3 of them have a significant interest in the relevant matters for the purposes of today. So they are all within Rule 5. The question then is the exercise of your I accept broad discretion, and I'm inviting you to exercise it in their favour for the following reasons. Now, making another general point that applies to all 3 of them, they have, because they work in the area and because they have worked in the area for a long time, they have seen system development, reform efforts and problems that have emerged over many years. They have seen what works, they have seen what does not work, they have their own understanding and insight into why immigration detention and the systemic issues within it can give rise to abuse and mistreatment. And this is what is happening, and this is why we think it is happening, is right at the heart of what you are trying to do with this inquiry. That's very important, as it's not even slightly peripheral to it, it's right at the core. And we say you should hear that insight direct from them. Now, we know that you say, and we recognise that you say, part of your response to that point is that you can do it another way. You don't need to be a core participant. You can get evidence, and they can provide evidence. And you've said that expressly in relation to bid and detention action in particular. But can I just say with respect, what the difficulty with that point is, which is that if you want them to participate and participate effectively to provide evidence that in which you are interested, then they need to know what the other interest is in order to respond to it. They need to know what other core participants are saying, and they need to know, and they may need to go and prepare, they may need to go and consider things, and they cannot effectively do that without being a core participant. Obvious reasons are the confidentiality undertakings that exist. If there is a possibility in theory that somebody within, for example, the legal team of which I'm a part, would be looking at material and go, I wonder if Inquest or whoever has something to say about that. But firstly, that depends upon us picking it up, and we do not know, obviously, all the inquest, detention action and bid know about something. If we are looking at something and there's some Home Office material about what is said in a meeting, bid might say, hang on a minute, I was in that meeting and something else was said, or the context of that needs to be understood. Now, I am not, in reading a set of papers, or DPG is not, when they're reading a set of papers, necessarily going to know that that is something that they have relevant evidence to give. You need bid themselves or detention action themselves to be reading that and thinking, all right, we have something to say about that. But even if DPG or whoever does pick it up, they can't do anything about it, because if they're not a car participant, it can't be shared for with them, because we're all subject to confidentiality undertakings. So there's a major practical problem with all of this. So it just doesn't work in the same way. They may well have things to say. We may not know what those things are to say until they say it. And even if we do, we can't do anything about it. So that's the real problem with just asking them to give a witness statement rather than be a court participant. I'd also emphasize that the involvement of those organisations is all the more important when you may not have as many detainees as one might have hoped to have had. We're dealing with a relatively short period of time. We don't know how many of them are going to be traceable and contactable, or who will play a part. We have a very small number as core participants at the moment, which will make these other sources all the more important. But I also emphasise this: if I am right, and there is an upside to having them involved in that way, because they might pick up important things that would otherwise not be picked up, and which will help you. This is not the consequence of this is not to make this an unmanageable inquiry, to not have lots of duplication of work, because there are, firstly, only 3 of them, so far as I'm concerned, and 4 before you today in total. That is not a large number of organisations. And secondly, as you can see, there is commonality of representation. So it's all going to be within the same number of representatives. And that's even before you yourself or counsel to the inquest controls the questions that are being asked, or controls the way things are being put in, etc., etc. So there is a significant upside to having them as core participants rather than as mere witnesses, and no real downside in terms of the manageability of the inquiry is that submission. The final general point I just want to make is learned friend for the Home Office has put in the case of EA, which is the EA in the Manchester inquiry case. I come back to that if I need to. But it is not a case that helps in relation to this case. I mean, it is a case about the survivors, the people who survived the tragedy in Manchester, and whether they could compel core participant status via Article 2 of the Convention. That nobody in this case, certainly not, I am not suggesting that there is an Article 2 or 3 compulsion to make these organisations core participants. None of that helps. As it happens, the EA case is all over to in any event. In relation to the domestic law provisions and the construction of Section 5, all it says is that in the particular context of the Manchester case, it was rational for the inquiry to come to the conclusion that it did. It doesn't give you any guidance on how you should exercise your discretion in the circumstances of this case. And I am saying you should exercise your discretion in the way that we say, for the reasons that we give, and whatever you're not going to get any resistance from me that there is a broad discretion. It's just about the way that broad discretion ought to be exercised. Now, those are my general points. Can I now just make some more specific points and take them in order? First, bid. You know who they are. They are an important NGO. They have detailed knowledge. They have detailed knowledge of detainees, detention, the conditions in which they are held, etc., etc. They have got that over many years, and that goes back to my point about they may well be in a position to say, hang on a minute, that's been considered before. That was raised in a meeting. The Home Office response to that at the time was this. It was done in a particular way, and this is why it was done in a particular way. And if it had been done in a different way, the outcome might have been different. That's clear, general, relevant stuff, which might well be helpful to understand that, particularly if one of the other core participants, like the Home Office, is putting in particular evidence about previous reform efforts. But I'd also add this. they are, as you know, and you can see in the submissions, one of two NGOs, the other one being GDWG, who is a core participant, who are present in the centre. And that means that they may well have specific evidence to give. And I just want to we make this point in general terms in our written submission. I just want to develop it slightly. They gave evidence to the Kate Lampard inquiry. They gave helpful evidence to the Kate Lampard inquiry. But they are also referred to in the evidence in the Kate Lampard inquiry that is given by GDWG. And you know, and I think is a genuine concern of yours, is the particular culture that operates within the centre and why it wasn't operating in a way that could prevent this from happening and allow safeguards to work. So why weren't people, and some of that is going to be around things like professional ethics. Why is it that a nurse doesn't do anything when asked to make notes in a particular way? Why is it that the IMB stands by where GDWG is making, on the face of it, perfectly sensible suggestions about doing things differently? Or what is it about the culture, and what is it that influences that culture? And you are going to have to reach findings of fact about what the culture was. Was it an appropriate culture, and if it wasn't appropriate, what caused it and what can be done about it? Now, a key bit of that is what GDWG say about their experience of dealing with G4S in particular, saying, we're making these representations, we make these suggestions, look at the response we get, and the submission that will be developed from that is, this is not an organisation that certainly at the time was interested in being reflective and learning and thinking that things could be done differently. Now that's an absolutely key issue for you, and that's why GDWG are in. But BID should be in too, because if you look at, for example, firstly, will they say the same thing about G4S? Is their experience the same as G4S is about whether or not this is a learning organisation? That's clearly important. No doubt G4S will put in their own evidence against GDWG, and you will want to hear from BID as to whether their experience was the same. So that's absolutely direct evidence that you'll need to hear. And you can see, and I'm not going to pull it up, but if you look at paragraph 14.25, for example, of the Lampard final report, that is GDWG giving evidence about BID's involvement in all of that and the way BID are working there too. And yes, the Lampard inquiry has a slightly different focus and slightly terms of inquiry, terms of reference to you, but on both of those inquiries, the substance of it is the same. It's absolutely key evidence. It's about the culture and what the culture was and why it was the way it was. And you've got another organisation that can give evidence about that, and it goes right to the heart. So for that specific reason, as well as the general reason about previous reform efforts and what's been happening over many years, we say that BID is absolutely appropriate to be in as a core participant in order to assist you and properly respond to evidence as it emerges. So unless I can assist you further in relation to BID, I will move on to detention action. Okay. The detention action also, you say, paragraph 13 to 14 of your decision, share the significant interest. And your concern about detention action was, as I understood it, that they were not at Brook House, unlike BID. The answer to that, I suggest, is the answer that you gave in your opening statement this morning, which is that this is not the focus of this inquiry is Brook House, but it can't be a wholly local focus because the arrangements and the policies that are applied at Brook House are very largely national. And that is what detention action knows about. And you can see from the written submission the extent of the work that detention action have done. It is proper, it is extensive, it is thorough, it has involved bringing some of the most significant pieces of litigation in this area. It is extensive experience of dealing with detainees who are subject to it. And they are going to bring a particular perspective about how does ACDT work on the ground? How does Rule 35 work on the ground? How are the medical arrangements being experienced on the ground? How is commissioning working, or the safeguarding systems working on the ground? And detention action have very intense, very thoughtful, very insightful experience about those on the national level and how they are being applied across the board, including at Brook House. And that is evidence which goes right to the core of it. It is evidence that we think that you will be interested in. They are involved in the reform efforts. They may well want to respond to other things that are being said. They might want to say something like, I don't know, we haven't got into the exercise yet. This is early stages. They might want to say, hang on a minute, the position that the Home Office took in relation to that issue was different to the position it took in a piece of litigation with which we were involved. If that was the case, that would be absolutely critical. And it's unless one of the lawyers involved happens to know, and that would only be by chance, you won't get that very significant piece of information. But because of Detention Action's extensive involvement in that kind of work and that kind of litigation, they are uniquely, we say, in a position to help. Now that's why we say you should exercise your discretion in favour of them. And that's all I want to say. I'm gonna virtually turn behind me in a moment to see if anybody wants me to add anything. I am in touch with my team through the wonders of WhatsApp, and if they've got anything they want me to add, then no doubt they will tell me. But otherwise, that will take me to inquest. And my key point about inquest, and I know again from your work at the PPO, you will know inquest particularly well. The point about inquest is, again, it's pulling in the experience and saying, hang on a minute, this has been explored in a different way or been looked at in a different way. And what they will know about is deaths in custody, including deaths in custody in the immigration estate. Now, Inquest wants to be able to say, if you are examining something about the medical arrangements in a particular case, they will say, hang on a moment, this has come up before. This is what the evidence was in that other case. This is what the response to that was. This is what the PPO said about this. This is what the prevention of future death report was from the coroner. And this is what happened in response. And understanding that there was, for example, a previous attempt to do something about it, and that was perhaps not followed, or perhaps it was followed but not in a particular way, or perhaps somebody decided that they were going to do something slightly different. That would be worthwhile you picking up and understanding, so that you can see that these things have been tried before and what was said about them before. Now, I mentioned in some of my earlier remarks the case of Prince Fosu. Inquest that's in our written submission. It happens to be a recent inquest of particular significance, but Inquest happened to know about it. That is an example of what they could do, because there will be lots of other examples of where they, which are not as recent or perhaps not as high profile, which say there is work here, there is thinking here, you could benefit from that. You know, one of the issues that came out of Fosu, for example, was about the use and the recruitment and the problems that arose from the use of locum GPs. And firstly, the fact that they were locum GPs, and secondly, the fact that they were the way they were inducted. Now, we would like to know. You might get into a position in this inquiry where understanding the frequency with which locum GPs are using and what the implications of that are for the way a detention centre is operated is going to be useful for you to know, and to say, well, hang on, that's what seemed to be happening there. Is something like that happening here? As it happens, Fosu follows on from an earlier inquest, which was the inquest into a death called a man called Brian Dalrymple, where very similar problems arose, but which wasn't fully explored because they didn't realise the extent of the problem. And I know that Ms. McGarhy knows about that case because both she and I were in it. And Fosu is the subsequent case to that, which shows, in fact, the problems are much more widespread than I think anybody in the Dalrymple case 4 or 5 years earlier ever realised. And that is what we need to give the opportunity to happen in this inquiry. Is this, in fact, something that's been happening a while? Is the problem deeper than anybody realised at the time? This is the opportunity for us to get to the bottom of it. What was the learning? What was the thinking? What was the insight on that earlier occasion? And the difficulty with it really is if inquests are not in and able to see things coming through as they are coming through, it is not easy to see, except by chance because somebody involved in the inquiry happens to have been involved in one of those cases. It's not easy to see how else you're going to get that material. So it is potentially very valuable. It is potentially extremely valuable. And for the reasons I've said about the way it's being managed and about the way it can be managed by your inquiry, but also managed by the commonality of representation, it's difficult to see what the downside is. They have valuable things to say. They're within Rule 5 in principle. There's no real downside to having it done in this way, and there's a considerable upside. So for all of those reasons, we say that core participant status ought to be extended to all three. I'd also note that the Deborah Coles of Inquest is on the independent advisory panel, so is in relation to immigration, in relation to deaths in custody, and therefore has that sort of overarching interest and awareness of what's happening at a very high level, which also is something you may well benefit from. So those are my submissions in relation to all three. Unless you have any questions about any of that, then that's all I have to say.
Thank you very much. That's very helpful, Mr. Armstrong.
Thank you.
Madam, I don't know whether Mr. Armstrong would like a moment or two to see whether his clients have anything else they would like him to say. We could always switch our microphones and videos off for a couple of minutes if that would be helpful.
Very happy to do so.
Thank you. I'm hoping somebody would have shouted at me if there was. I can see somebody's typing. Let me just take a moment.
Yeah, we'll give you a moment.
No, I think I'm being told that's fine. Okay. If I suddenly get something, I might put my hand up, but it's I think I'm okay. Thank you, Chair. Thank you, Ms. McGowan.
Many thanks.
In that case, Madam, may I invite Ms. Harrison to address you on the core participant application of medical justice?
Thank you. I think before I begin, I need to apologise for having a chorus of dogs in the background. I wasn't aware myself, but I have had text messages saying you need to do something about them. And if they do it again, I'm afraid there's very little that I can actually do because they're outside and it's when people come. So I apologise for that. But that's
no problem. Thank you.
Consequences of being at home doing the day job. So can I just say before I begin my submissions, because we have made some additional material available to the inquiry recently, I just want to make sure that it's before you and you've considered it, because it was in part in response to both the counsel to the inquiry's note and other information that had been provided from the inquiry, that we provided a witness statement with a table of information held by Medical Justice on its databases of a cohort of individuals who were detained during the relevant period. So I hope you've had an opportunity to consider that.
I have it to hand, thank you, yes.
And in addition, because we were concerned about constraints on time, we've also provided you with some other additional submissions that I'll refer you to, but only briefly, which again, I hope that you have an opportunity to read at your leisure.
Thank you, yes, I have those too.
I'm grateful. So turning to the basis upon which the application for medical justice to be granted core participant status was indicated was going to be refused. Like the situation with the other three NGOs, the inquiry accepts that medical justice does have a role and an interest in the subject matter of the inquiry, but that it is not a sufficiently direct or significant interest falling within Rule 5(1)(a), or again under 5(1)(b), that whilst there is an interest, it's not sufficient. So as we've set out in our submissions, we respectfully submit that the inquiry has fundamentally failed to recognise and to proceed upon the basis that in fact medical justice, in the many ways in which it has been engaged directly through its casework, through its policy and lobbying work, and through its research and monitoring of practices and participation in in a variety of other forums, both statutory and informal, does in fact have a direct and substantial interest in the subject matter of the inquiry, and that error, which we respectfully submit, clearly underpins the exercise of the indication of how discretion will be exercised, is wrong and needs to be reviewed. We say that because we have identified, and I don't think this is disputed, that when one looks at the terms of reference of the inquiry, it's quite plain that medical justice has direct material from a number of sources relevant to each of the 6 key areas that have been identified, in particular number 2, 3, 4 and 5, which concern the question of methods, policies and practices and how they may have caused or contributed to the identified mistreatment, the issues of clinical care and how they have contributed to identified mistreatment, and what could be done to assist in recurrence. So their experience goes directly to core terms of the inquiry. And when one then looks at the opening statement that you gave and identified in more detail the sorts of factors that were going to be at the heart of the inquiry, and I take that from, it's on page 29 of the bundle that was put together by DPG, and it's from your opening statement, a list of matters which we say medical justice clearly have first-hand direct knowledge of, and that includes the staff management and culture at Brook House. It clearly includes the assessment of vulnerability, the relevance of Rule 35 and Rule 34, and the adults at risk policy, clearly relevant to the extent and suitability of the specialist mental health provision, control and restraint techniques, use of measures to deal with non-compliance, use of segregation, management of self-harm, food refusal, management of healthcare staff. When one looks at the material that was provided to the inquiry, each and every one of those key factors, medical justice has direct knowledge, both in terms of what happens on the ground, as well as knowledge of the institutional practice and culture of individuals at the IRC, including directly at Brook House IRC, and in particular also of Home Office officials at a high level who have been responsible for some time in overseeing and implementing policy. When it then comes to the second aspect that you identified in your opening statement, the adequacy of safeguards, again, that's a key matter that medical justice has direct information and evidence that it can provide on the recording and the monitoring of use of force, the oversight mechanisms, it having direct discussion and liaison with the HM, with Her Majesty's Chief Inspector, as well as operate with other key bodies like the IMB. In terms of 3 and 4, which, as you've indicated in this hearing, are of particular importance and are going to be of a special importance when it comes to going forward, and in light of the delay that there has been, looking at what changes have been made and are those changes adequate. I will go to, I want to develop that a little bit further because it's not something that we have specifically focused on, but there's material that's clear that where we can provide vital input on those issues. So can I then deal with why we say, contrary to what appears to be the assumption of the inquiry, that we have no direct first-hand experience of Brook House. And I hope that in addition to the submissions that we made, the witness statement with the table of information that we have been able to extract, that medical justice has been able to extract from its databases confirms what we have said in principle as part of our submissions, that medical justice through its casework facility, which is a central part of the service that it has been providing over a significant number of years through its casework staff and also through its volunteer doctors. As you will have seen from the table, has direct communication with all detainees who were referred to them. It includes not simply referral, but also emotional support and arrangement of medical legal reports, but critically through direct communication with detainees present during the period, as well as follow-up through engagement with Brook House, as you'll see in a number of the boxes. It isn't simply concerned with the detainee. The information that is obtained results in engagement with Brook House IRC and also with IRC medical staff. So you'll see that referred to in a number of the boxes. So in terms of being present and communicating directly with relevant officials and staff at Brook House, that medical justice will be able to provide you with a first-hand account of that information. And as you can see, when it comes to even a very summary, preliminary analysis of the information that they currently hold, it is evident that medical justice will be able to provide detailed, granular information about all of those, many of those key aspects of the detainee experience, whether that is the incidence of serious mental illness, which is not properly identified and or treated, the management of the risk of self-harm and suicide, the use of force, the response of healthcare departments, the response of the Home Office caseworkers, the effectiveness of the safeguards, all of those matters which you've set out clearly on a number of occasions now and repeated, that are going to be key to your ability to find facts as to what the detainee experience was, as well as to understand why the mechanisms for both safeguarding and protecting the interests of vulnerable detainees did not work. You have to start from the premise that, contrary to what appears to be the understanding in the minded to refuse letter, medical justice will be a body who has first-hand material to provide to the inquiry, and that will be both its caseworkers and its staff, as well as the number of doctors who have physically attended the detention centre and prepared detailed medical legal reports. And we would suggest that it wouldn't be appropriate simply for each one of those doctors to be the source of information. Certainly they will have information, but the doctor themselves will not be in a position to assist the inquiry with understanding the context, both in terms of the casework context, the Home Office casework context, the decision-making, the failures of the safeguards. They will be able to identify the diagnosis that's been made, and also they would be able to identify the impact of detention. But in terms of understanding the systemic failures that explain the reasons why vulnerable people remain in detention when they shouldn't be and aren't released, that will require critically the involvement of medical justice to analyse the significance of that material. So we say that that medical justice did have a direct role, and it's going to be, we respectfully submit, a critical direct role, because it's evident from the information that's been provided by the council to the inquiry that there is a fundamental potential difficulty that the inquiry finds itself in because of the, in part because of the timing in which you're now seeking to obtain detainee experience, that having not been secured at an earlier stage. It is a matter that is of grave concern. It's something that on behalf of Mr. MA, we have been raising for some time with the inquiry, that there is a real danger that key material from detainees themselves will not be captured by the inquiry and will not be available. There's obviously going to be a cohort of relevant people who've been removed. There will be others who can't be contacted, and there'll be a number of others who, for reasons that Ms. McGahey has set out, will be very reluctant and concerned to be approached by the inquiry to participate. Some of those critical obstacles that the inquiry faces in terms of obtaining what it accepts and quite properly treats as material that should be at the heart of the investigation can be provided by medical justice from its existing casework and from its ability to be able to approach potential detainees from this cohort of people that they've already identified, and can do so from a position, unlike, as the inquiry accepts, a position of existing trust, but also with the ability to provide support to individuals if they were to consider that they wanted to provide their evidence. Of course, we can't give guarantees about what we can do. We have taken the preliminary steps in terms of identifying what is in our database to illustrate to the inquiry how critically important this material can be. But we say, without the ability to be participating in the inquiry as a core participant rather than a more passive witness, we simply will not be able to have the effective role in securing for the inquiry this key material of detainee experience. And that in any event, and even if there are detainees who are going to be captured through the inquiry's approach, medical justice itself has a first-hand experience that wouldn't just give you the raw account of what it was like to be at Brook House. They will be able to do so informed from a uniquely experienced organisation that has an ability to provide the inquiry with the full picture of how the detainee experience does fit within within the context of the practices of officials within the detention centre, within the practice of healthcare staff, who they all have, who medical justice has direct communications with, as well as understanding, a deep understanding of Home Office casework practices and their role in terms of decision making and in enforcing and the safeguards. So it will be an ability to both understand, to present and to understand the detainee experience from the context of its systemic position and what we are confident will be able to be demonstrated systemic failure. So that's our first-hand knowledge of detainee experience that we can bring to bear. We think it is also important for the inquiry, when it comes to considering systemic issues, to also have first-hand information from those who have, as medical justice have done, been participating for over 15 years in extensive meetings and communication as part of regular stakeholder meetings or consultations with Home Office officials. So it is going to be important to understand the institutional culture and practices that arise in the Home Office itself as the body ultimately responsible for the way in which these detention centres are run. And medical justice, through having worked directly with key civil servants who you'll see have in fact been in place over very many numbers of years, the same key civil servants overseeing this process have been in regular contact with medical justice, and medical justice will be able to provide to the inquiry a detailed first-hand account of how these officials respond both to their evidence, which they've provided over a number of years through detailed casework research of abuse covering and failure covering many of the topics that the inquiry is going to investigate, as well as critical legal cases, both on individual and systemic bases, and how the Home Office responds to the many pressures that they have faced to remedy the clear deficits in the law and practice at these facilities is going to be a critically important part of identifying any systemic causes for the abuse, but also obviously key for this for identifying lessons to be learned and whether changes that are proposed are going to be adequate. And if I can just refer you in respect of those two important parts of the inquiry that you've identified, both in the context of what the situation was in 2017, but also crucially how there has been a response. In that regard, medical justice, we would respectfully submit, is in the best position to be able to assist the inquiry. So if you consider the application that we made, a number of paragraphs are relevant for considering the information and insight that medical justice will be able to provide. Clearly, it's apparent that the adults at risk policy, its formulation and implementation, is a key aspect of the Home Office's response to the Shaw Review and the widespread evidence of failure in respect of vulnerable adults in detention. If you look at paragraph 18 of our application, which is on page 6 of our bundle under the heading Policy Advocacy and Legal Reform, as we say, medical justice is a key stakeholder in Home Office discussion and meetings. And in recent times, following 2017, it has played a proactive role in meetings with the Home Office and in discussions over changes that need to be made to the adults at risk policy. That has meant that in that period, medical justice has brought both important strategic litigation, demonstrating that the adults at risk policy was fundamentally flawed in seeking to limit the definition of torture, and also conducted 2 investigations into the treatment of vulnerable adults, producing 2 reports setting out the failures in the adults at risk policy and the impact of those failures. Those 2 reports are dated 2018 and 2019. They referred to at paragraph 16, putting adults at risk is the 2018 one, and failure to protect from harm of immigration detention is 2019. And so medical justice has already begun the task of identifying why the response of the Home Office has not been adequate, either to the previous Shaw reports and following the exposure of abusive practices by Panorama. That is ongoing work that they do on a regular basis. So they also have more material, updated material, that will be directly relevant to the question of what changes have been made and whether they're adequate in respect of a key policy, which is the adults at risk policy. But underlying that will also be material about the effectiveness of Rule 35 and other safeguards. And so in that respect, there will be key information and insights that medical justice can provide. We set out in some greater detail for your information at 24 and 25 about the role in response to the failures of the adults at risk policy. But then if I could ask you then to look at paragraphs 36 and 37, and you'll see that it has had and continues to have ongoing roles in relation to issues concerned with the management of mental health risks and clinical care in detention as a member of the Refugee and Asylum Forum and the Adults at Risk Forum. And in particular is providing bespoke training for the Care Quality Commission, which is the independent regulator of health and social care, in 2009 concerning Rule 35. It's not clear to me whether any health, whether the NHS or other relevant health bodies have been approached to participate, or certainly there's no indication that they've got core participant status. But clearly the role of the NHS is important in healthcare issues, and it is medical justice that are providing bespoke training to the regulatory body, the Care Quality Commission. And in addition to that, if you go to paragraph 52 of the document, you'll see that it is also having regular ad hoc meetings with the, and has done so since 2017, with the Deputy Head of Health and Justice at NHS England to provide information concerning their clinical casework on behalf of detainees. It is the body registered to engage in consultation concerning the NHS's health needs assessment at the Heathrow IRCs. And it is attending workshops and advising both Public Health England and the Home Office on draft standards and feedback on clinical practice for their casework, and to provide policy analysis of the draft standards document. And so that is clear, direct institutional information directly relevant to the questions relating to clinical care. And we say puts medical justice clearly in the situation of an organisation that has significant interest in the outcome and ability to provide this inquiry with key insights and information. That institutional role, that role with the NHS and the Care Quality Commission also reflects the fact that medical justice is heavily involved with the professional organisations, the Royal College of Psychiatrists and the BMA, and the Faculty of Forensic and Legal Medicine at the Royal College of Physicians. And those roles allow it to bring to bear extensive evidence and information across the whole gamut of expertise relevant to the inquiry. We accept that the inquiry is going to obtain its own clinical expertise from Dr. Cohen, if she's approved, and we would suggest from a psychiatrist. However, that will not be a substitute for an organisation like Medical Justice that has detailed first-hand knowledge, is an active participant in seeking to ensure and to expose failure in practice across a number of areas, and seeking actively and proactively to remedy it and provide solutions. It would simply be a gross omission, we would respectfully submit, for them not to be a core participant in this inquiry and substantially undermine the inquiry's ability, A, to find full facts, both in terms of detaining experience, the systemic issues, and in making findings which are key for lesson learning. So that's why we say that medical justice has a direct and substantial interest. We also would wish to emphasise, because it seemed to be the focus of the reminder to refuse letter, that it's clearly not limited to clinical matters. It covers, clearly is very extensive experience in relation to clinical matters. But as you will have seen from the submissions, and also in particular when one considers the information that we've provided in the table, medical justice's information and ability to provide analysis covers not just clinical treatment, but the methods of use of force, constraint, segregation, management of self-harm and suicide, as key aspects that are obviously going to be critically important to understanding the ill treatment of MA and why it happened, as well as clearly detailed knowledge of the systemic failures with regards to safeguards. It would also be right to say that medical justice does have, through its direct communication and liaison, information about the complaint system. It's done reports in the past about the inadequacy of the complaint system. It has regular communications with Her Majesty's Chief Inspector. It is in communication with the IMBs. So those oversight bodies, which again is an important aspect of understanding why this abuse occurred and wasn't identified except through undercover reporting. Medical justice will be able to provide insight about the operation of those organisations and the limits that they have in terms of their ability or have had to scrutinise and hold to account and expose what was happening in the detention centres. So then that comes, I think, to the other major reason why the inquiry concluded that it would be minded not to grant CP status to medical justice, and that was the suggestion that being a witness would be adequate and would be sufficient. We have sought to explain in our written submissions why being a passive witness is not going to be effective and is not going to be sufficient to ensure that all of the information and insight that medical justice has can be utilised by the inquiry. Mr. Armstrong sought to illustrate how having a role as a CP for the other NGOs it would be of assistance to the inquiry, and that plainly applies in the context of medical justice, both because it would be able to provide rebuttal evidence from accounts and evidence that is given by the public authorities, by the Home Office and G4S, which would assist the inquiry in ensuring that it conducts what Mrs. Justice May indicated needed to be a rigorous and forensic examination. And that would be first-hand material in response to evidence that the Home Office and or G4S provides to the inquiry. It would also permit them to assist with identifying and providing detainee material. Simply can't be expected to do that if our role is as a witness. We would have to have a proactive role and engagement with the inquiry if we were going to provide the further detail that is clearly going to be available from what's evident in the table. And we would be in a position to suggest lines of inquiry and further documents to the inquiry. One point that I think is important to make from the counsel to the inquiry's written submissions is that it's intended to obtain the documentary evidence from the Home Office of those detainees who were held during that period and who are on the identified on the video. But what is absolutely apparent and clear, and I hope it is at least indicated in the table, that without knowledge of how this system operates in practice and with the kind of experience that medical justice has, that simply obtaining the documents will not begin to provide the inquiry with useful information and insightful information. What is evident from working in this field, and certainly medical justice will be able to provide you with evidence of that, is often what's missing from the documents is as important as what's in the documents. One has to be alive to the fact that there is a clear pattern where healthcare records and other records are inadequate, don't reveal the key material, where that material may be found through other documents that it's known through experience that the Home Office holds. All of those detailed insights will be lost to the inquiry if medical justice's role is simply that of the witness. And we say that it will be a deficit in the inquiry's ability to provide the sort of rigorous scrutiny and forensic examination that has been absent from the previous inquiries, which has been accepted by Mr. Shaw, both as in his role as the PPO and in the two Shaw reviews. One has to ask the question why it is that those investigations, as is now readily accepted, into abuse of a similar kind did not result in lessons being learned, and even getting to the bottom didn't result in getting to the bottom of why this abuse was occurring and lessons being learned. And in our respectful submission, certainly it's the experience of medical justice, a critical failure is the fact that there is in truth a parallel process that takes place where the Home Office gives their account and the NGOs who assist detainees and experience the process from a different perspective are never in a position to challenge the account that's given by the Home Office or other public authorities. And we say it will be a major missed opportunity if this inquiry doesn't permit a mechanism whereby those who are most informed about how this system operates and how abuse occurs do not have an active role. And that is the NGOs. We say from the position of expertise across the spectrum, in particular with medical expertise, then medical justice is the obvious organization to have that role. But we would say that that also does apply to the others in the way that Mr. Armstrong has submitted, but ultimately the inability and the exclusion of an organisation like medical justice from having a proactive role in this inquiry, we respectfully submit, risks similar failures in the previous investigations being replicated. Finally, then, the other observation that was made was that there is an NGO already given core participant status. We've obviously stated in writing that that can't be a basis for saying that other NGOs and obviously in particular medical justice, should not also be awarded core participant status. We respectfully submit that the reasons that it was granted for the Gatwick Detainee Support Group equally apply to medical justice when you now have the much more informed information from its casework files as to the fact that it was, through its staff and through its doctors, an active participant on the ground in the detention centre in respect of a significant number of individuals who are in the category of key detainees who the inquiry wishes to obtain information about. And clearly its expertise, knowledge, goes much wider than the detainee group for the reasons that I've sought to develop, and which go directly into the heart of a number of key matters that the inquiry is going to cover. So for all those reasons, we submit that you should review your decision and remake it, and conclude that medical justice is not only an appropriate core participant, but in fact will have a vital role to play in ensuring that the inquiry's tasks in obtaining the detainee experience, in understanding the systemic failures, identifying if change has taken place and its adequacy. In all those key respects, medical justice is the organisation that can provide effective assistance to the inquiry, and from an independent perspective based on many years of detailed work and experience. I may just need to double check whether there's anything that I've missed.
Absolutely, do take a moment to do so.
I think the only point that I'd want to emphasise from the additional submissions that we made is that if it is of assistance to the inquiry, we provided details of other investigations where there were multiple NGOs who were considered to be able to provide direct material, even in circumstances where there were individual core participants. And the two examples that we gave at paragraph 15 of the document was the infected blood inquiry, where 9 charities have been granted core participant status. And in particular, in terms of the context, if you look at the independent inquiry into child sex abuse, that has 2 NGOs, one Child Redress International, and 2 Every Child Protected Against Trafficking. So those are organisations similar to medical justice that have a role in providing information and have contributed to policy work. So there's clearly is precedent for multiple NGOs to be able to contribute to inquiries such as this.
Thank you, Ms. Harrison. Did you want to take a moment to check whether you haven't had any further instructions from your client?
I can do that.
Okay, we'll pause for a moment for that.
No, those are all the submissions that I have. Thank you very much.
Thank you.
Madam, that concludes all the agenda items for this afternoon's hearing. I'm very conscious of the time and also the fact that some people have left the call. So I don't think it will be possible or fair to invite submissions on any other business or anything not raised on the agenda. We have a hearing now either on the 30th of November or a date close to that. And it may be that there are other matters that cannot be resolved between now and then in correspondence that they can be raised there.
Thank you, Ms Magahi. Okay, well, I'm very grateful to each council for the submissions on behalf of their clients. I'd like to reassure you that I've listened very carefully to everything that has been said this afternoon, and I will take a great deal of time and careful consideration to make sure that I reflect on those points. So thank you all. As Ms Magahi says, that concludes our agenda. So it just remains for me to say thank you to all of you for your attendance and contributions this afternoon, particularly as so many people have managed to remain on the call and we've gone on late into a Friday afternoon. So thank you all very much.